Hello to everybody. I'm another time Francesco Pesce. I'm a contract researcher in the University of Genoa in Italy. And I'm one of the 3 members of Italian teaching team that is composed by me, by Laura Carpaneto and Chiara Celerino, that will be here with you next week on Wednesday, I think. And first of all, I'm really pleased to be here in front of such a mixed audience of people coming by different European countries, especially Baltic countries. And also, I know you are coming from different fields of university studies, so not only law, but tourism or economical science and so on. So I try to be very general and to approach the low profile of European Union from the beginning in order to make you understand if it's possible. If it's possible. And from a methodological point of view, the first thing is that Italian teachers are lawyers. So I know it's important to consider the mediation from the point of view of one's feelings, one's emotion, but we are necessarily influenced by our background in the law studies. So I think it's your task try to unify all the notion that you can understand from me, from the other teachers, and please consider that I'm not used to evaluate other aspects of mediation, but only the law profile. And another thing, I think it's very important to consider the mediation topic from the psychological, from the sociological point of view. And today we will try to consider how the European Union acts in the mediation topic. So, first of all, I want to know who is able to speak about European Union, who of you studied the European Union law at university or during the studies. So, okay, I know that Italian team, but the other ones, okay, not so many, okay. Then, the title of my lecture is Introduction to EU Civil Judicial Cooperation. So, the main task is to understand what is the link, which is the link between mediation from one side and civil judicial cooperation in Europe from the other side. You have to consider that's a long time history. You can notice from the slide. The European community phenomenon is very ancient. It started in 1957 with the Treaty of Rome. And the thing that you have to consider is that in the first moment, the European community didn't have the purpose to act in the civil judicial procedure. So the first purpose of European Union, economic European community at that time, was, you can read, granting the free movement of so-called factors of production. Factors of production are goods, services, capitals, and workers. So at this time, in that moment, we can't speak of mediation or other civil procedure in general and European community. European community was only aimed at granting this kind of free movement. The only purpose of European Union was an economic purpose. Today, the situation is very, very different. You know that European Union is acting on very different profiles, on very different topics, and so European Union increased its scope of action towards a large number of different aspects of citizens' life. So you can find European rules on labels of foods in the market. You can find European rules on passenger rights in the flights, and so on. And today, you can even find European rules on civil procedure and on mediation. I wrote that tomorrow, I think and I hope there will be future development in the European integration, even if it's today really uncertain, because many doubts are arising on the European integration, and especially in some member states. Greece and Hungary, first of all, but even in Italy, we have some politics parties that are against European integration, and they obtained discrete success on last elections. So the integration today is still proceeding, but we don't know the situation in the next future. Why European action on alternative dispute resolution? I said that the action of the European Union is today interesting very different fields. And in the field of civil justice, the European Union noticed that there are many problems of increasing proceeding duration due to the increasing number of legal proceedings in general. So citizens are moved to bring their complaints to the courts, to the judicial courts, and that's a problem because the courts are not able to offer such a large number of proceedings. And they are not able to grant an acceptable time for the decision. I wrote this notion of Italian torpedo because Italy is especially well known for the duration of the proceeding, civil proceeding. And in the intellectual property field, they call Italian judgment Italian torpedo to indicate the large duration of the time. PPU procedure before ECJ. Why I mentioned the PPU procedure and what is? I mentioned this PPU procedure because the duration of the proceeding is not only an Italian problem or a problem that arises at national level, but is also a problem that is arising at European level. ECJ is European Court of Justice, the Court of Luxembourg. And even in the Court of Justice, due to the increasing number of member states, due to the increasing number of complaints, there are many problems to judge in an acceptable frame of time. So they were obliged to introduce a different proceeding, PPU, that is Procédure préjudiciale d'urgence, that is a very fast proceeding for a very small number of topics that needs a fast decision. You can think to child abduction. In that case, it's necessary to arrive in a very short frame of time to a decision. So, European Court of Justice introduced PPU proceeding. And I don't know at all the situation in Latvia, in Lithuania, and in Estonia. But I have an example of the Italian situation that I think makes you understand how it is important to introduce an alternative dispute resolution system. We had, in 2006, a decision of the Constitutional Court on an article of our civil code, a preliminary article of our civil code, that is Article 18. In 2006, Constitutional Court said that Article 18 of our preliminary rules of civil code is unconstitutional. It seems to be a normal judgment. The problem is that Article 18 was repealed, was cancelled from our system in 1995. So, 11 years after the elimination of that rule, Constitutional Court was obliged to state on the unconstitutionality of that rule. And why? Because the judgment was the judgment started before the elimination of the article. So the judgment started in 1993. In 1995, the legislation was changed, and in 2006, Constitutional Court was obliged to spend time and work saying that an article that was no more existing was unconstitutional. So you can understand it's a very huge problem. And which is the problems in speaking of ADR at national level? Danarone yesterday introduced these kind of problems. First of all, sometimes citizens don't even know to have the possibility to solve their litigation through an ADR system instrument. So, ADR is quite new, and it's a difficult problem to disseminate the knowledge of alternative dispute resolution towards the citizens. Second point, sometimes lawyers are not, sometimes and also often lawyers are not interested in promoting an ADR towards their clients. And it's very simple to understand why, because judicial litigation is more profitable. And in Italy, where judicial litigation is so long, it's sure that you can have a more important remuneration from a judicial litigation than from an ADR. So, one possibility to disseminate, to spread the use of alternative dispute resolution is surely the possibility to introduce mandatory mediation systems. So, if you oblige the citizen to use the mediation before going to the court, you are surely, you can surely make the mediation be used. But we'll see the day next tomorrow that we tried to introduce a mandatory mediation, but now the Constitutional Court cancelled the mandatory character. So in Italy, mediation is another time a possibility given to the citizen and especially given to the lawyer that generally are not interested. So, speaking about mediation and European Union law, we have, first of all, to distinguish two different situations. We can have mediation at a national level and the so-called cross-border mediation on cross-border disputes. The first one, national mediation, regards the total internal situation, and it is ruled by each member state's civil procedure. Also today, each member state can rule the internal mediation with the totally freedom from the application of the European Union law, while only cross-border disputes are directly interested by European action. What is a cross-border dispute? The Directive on Mediation of the European Union, Directive 52/2008, says that a dispute has to be considered cross-border when at least one of the parties is domiciled or habitually resident in a member state other than that of any other party. So please consider that they are completely different situations. The first one totally ruled by national legislation. The second one interested by the intervention of the European Union with the Directive 52/2008. The fact is that European Union action is a strong incentive to rule the internal mediation system. And in Italy, it happened that when the legislator was forced to approve some rules on cross-border mediation, the same legislator approved the rules regarding internal mediation. I wrote that such a way of proceed can prevent a situation of reverse discrimination. It's a very huge problem when we speak about European Union law. What is reverse discrimination? Sometimes it happens that thanks to European Union law, the cross-border situation are considered in a more favorable way than the internal situation. So, applying regulation directive from the European Union, you have to recognize some rights to citizens coming from other states, while you can decide for the rights of your country's citizen. Well, sometimes it happens that applying European Union law, the citizens of a state, of a country, are in a bad condition, in a worse condition than the citizens of other countries. And that's the reverse discrimination. So each country wants to grant to its citizen the same rights that are granted to the citizen coming from other countries by the European Union. So when European Union approved a directive on cross-border mediation, many countries, and Italy too, were forced to approve rules on mediation at national level. We didn't have before such a large number of rules on alternative dispute resolution in Italy. Then we approved together the part imposed by European Union and the part relating to total internal situation. Why we are speaking about mediation and civil judicial cooperation? I said at the very beginning of the lecture that in 1957, when the Treaty of Rome was signed, and so the economic European community was created, the economic purpose was the only one of the community. In 1997, a new treaty was approved, a very important treaty, and it is the Treaty of Amsterdam, entered into force in 1999. With the Treaty of Amsterdam, member states asked to European Union to approve some rules in the field of civil judicial cooperation for the first time. European Community is finally allowed to approve direct rules in matters relating to civil judicial cooperation. So you can notice that before Amsterdam treaties, the only act relating to civil judicial cooperation in Europe was the 1968 Brussels Convention, that was an international instrument promoted by European economical community, but not concluded by the same community, because she had not such a competence. So, before 1997, the community couldn't approve any act in the field of civil judicial cooperation. The member states had the possibility to approve a convention that was not related to the participation to the community. After 1999, the entry into force, European Union can finally approve such type of act, like the directive on mediation. It's only an example, but after Amsterdam Treaty, European Union started to approve many regulations in the field of civil judicial cooperation. So I wrote Regulation Brussels I on civil and commercial matters, Regulation Brussels II on family law, Regulation Rome I, Rome II on contractual obligation and torts, and finally, Directive on mediation. Directive on mediation is Directive 52, 2008. All these acts are directly approved by European Union institutions. Now, the member states are not in the position to approve each act like with an international convention, like in 1968 with the Brussels Convention. This regulation and the directive on mediation are directly approved by European Council and the European Parliament. And they are directly applicable in the member states. So in Italy, in Lithuania, Latvia, and so on. Now, member states in these particular fields cannot legislate at national level anymore. Once the European Union has approved an act on a special field of the law, the single member states cannot legislate anymore on that field. Civil judicial cooperation is a very, very wide concept. It regards not only, but especially these 4 points. Conflict of jurisdiction, conflict of laws, recognition and enforcement of foreign decisions, and access to justice. Conflict of jurisdiction regards, another time, cross-border litigation. And these rules are aimed at granting a unique judge to be competent in the whole Europe. So, if an Italian citizen is in litigation with a Latvian citizen, the European rules are supposed to say if the Italian or the Latvian judge is competent in this litigation. Only one judge is competent in all Europe. Conflict of laws. You have to consider, generally, law students knows that a basic principle of international law is that one judge is not forced to apply his own legislation. We generally use a Latin nouns, and we say that forum and use don't go together. Italian judge can apply Latvian legislation, but Latvian judge can apply and has to apply Italian legislation. So conflict of law rules indicate which is the rule, which is the legislation that has to be used in a proceeding. Recognition and enforcement of foreign decision. So these are the rules that consent to recognize and enforce a foreign decision in each country of Europe. Foreign decisions have to be treated in the same way than the internal one. Last point, the more important for the mediation, is access to justice. European institutions want that the access to justice is granted in a way as wide as possible. And in that particular perspective, mediation is an instrument to grant such an access to justice. Mediation Directive 2008. I don't speak about the content of the directive, since Laura Carpaneto will speak about it next week. But I introduce the topic, and I want you to know, first of all, why European Union approved a directive in the topic, in the field of mediation. So, who of you knows what is a directive and which is the difference between the directive and the regulation of the European Union? Yeah. Yeah, perfect. So basically, the difference is that the directive has to be implemented and the regulation is directly applicable. We say that the directive is binding for the states, for the countries, and the regulation is binding for the citizens, directly for the citizens. Why? Because the directive obliges the member states to approve a particular legislation, while a regulation can be directly applied by the courts in all member states. I spoke about principle of subsidiarity, and we can find the principle of subsidiarity in the European Union Treaty, Article 5, which is the link between the directive on mediation and the principle of subsidiarity. First of all, it's one of the three basic principles of the European direct action. You have the principle of conferral, the principle of subsidiarity, and the principle of proportionality. The European intervention in all the fields of law, so even in the civil procedure, has to respect these three principles. First of all, European Union can act in a policy area if the action forms part of the competencies conferred upon the European Union by the treaties. So, European Union can act only if the member states decided to give to the European Union the competence in a particular field. But it's not sufficient. The European Union can act only if the action at European level is necessary to achieve the objectives set by the treaties. So, if the same objectives can be reached at national level, European Union cannot operate at a central level. And finally, principle of proportionality says that the content and the form of the action does not exceed what is necessary to achieve the objectives set by the treaties. So, European institution can rule a particular topic only until it is necessary to grant a uniform legislation in the whole Europe. It's not necessary that you copy all the slide. I just wanted to show that these three principles are contained in Article 5 of the Treaty of the European Union. That, and you find also the explication of each principle. So, the principle of subsidiarity in particular is related to the choice of the approval of a directive on mediation. Because European Union decided that in the field of mediation, member states have to be free to approve internal rules, and the European Union only gives to the member states the purpose, the objectives they have to reach. In the Mediation Directive, you can find the recital number 28 that says that the principle of subsidiarity is respected. So, since and only since the objectives of the directive cannot be sufficiently achieved by the member states, so European Union can operate at a central level. And principle of proportionality, at the last part, the directive does not go beyond what is necessary in order to achieve that objective. Relating to mediation was not necessary to unify the law of the member states, and it was sufficient to harmonize the law of the member states. We generally speak about unification for the regulation, and we speak about harmonization for the directives. With the harmonization, the objectives that all member states have to reach are the same, but the legislation is different. With the unification, the legislation is the same in all member states. All member states have to apply the regulation, like regulation Brussels I, Brussels II, and so on. So, European institutions consider that in the field of mediation, a certain freedom could be left to national initiative in ruling cross-border mediation. So, they choose to fix only the objectives, and it's really important for a directive, the deadline for the approval of national measures. The deadline was fixed in 2011. So until 2011, all member states had to approve national measures, national legislation on mediation, cross-border mediation, at least. Which are, we can just speak a little bit of the objectives of the directive on mediation. Which are the objectives that European Union fixed for the member states and have to be achieved by member states in ruling cross-border mediation. The first objective is to ensure the quality of mediation. So each member state is completely free to decide how to grant a quality mediation, but each member state has to provide a system to grant a mediation of quality. Generally speaking, member states organized some courses for the mediator in cross-border disputes, but even in the internal one, to grant that mediators have not only the law background, but even the psychological or sociological background that is necessary to approach the topic of mediation. The second objective of the directive is to ensure the use of the same use of the mediation proceedings. So that point relates to the fact that each member state has to approve a legislation on mediation. Third point is ensure the enforceability of agreements resulting from mediation. So mediation is completely unuseful if we can't enforce the result of the agreement. Once we have an agreement between the parties, we have to be sure that this agreement can be enforced in the same state where the agreement was reached, but also in all other member states of Europe. Fourth point, the directive wants the states to ensure the confidentiality of mediation proceedings. It's an important goal to reach, the fact that mediation is a delicate question between the parties, and so the task to solve this dispute is delicate and very, very confidential. So member states have to provide a mediation inspired to the confidentiality principle. And the last point that the directive provides is to ensure that the use of mediation does not prevent the parties from the possibility to go to the court. Obviously, in the case that mediation fails. It's sure that the parties don't use the mediation if they know that in case that the agreement is not reached, they cannot go to the court. So the directive obliges the states to introduce a mediation instrument, a mediation mechanism that consent to the party to go to the court in case that the agreement is not reached. Well, I think that we can continue next time. I think you are quite tired, so it's okay. We introduce the European concept, and next time we go on.